Tips from an Employment Tribunal Judge, Part 4. This time we are talking tactics, specifically the tactics that this judge sees respondents using in his court. When I say respondents, I mean employers. So he mentioned 3 tactics that he sees. The first one is strikeouts, the second one is cost warning letters, and the third one is not immediately conceding a disability. So what is a strikeout? This is something that you or the other side can do pretty much at any point through the tribunal, but employers often do this right at the beginning, come in really hot and just try and get the whole case thrown out right at the beginning. They say, oh, there's no chance of succeeding. Judge, will you please just throw this whole thing away? And obviously that's really upsetting and distressing for someone who doesn't know that it's a tactic and they worry about how they're going to deal with it. So please do know this is often a psychological thing, and you probably will need help from the tribunal to refine your claim, especially if you're representing yourself. But that doesn't mean that they're just going to chuck the whole thing out immediately. They will work with you to try and understand what your claim is, if it's in time, all of those things. The second one is my old nemesis, the costs warning letter. So if you search on the internet for cost warning letter, you will probably see this face because I have ranted about this so much. This is such a scary thing that employers will send these letters that basically say, you're going to have to pay all our legal costs. And it terrifies people and it makes them drop their case, when the reality is that when the employer actually does apply for this, they are only awarded it in 6% of cases based on the latest data that we have. 6%. Oh. So this judge has seen it as well, and he also is aware of how commonly they are awarded. So please know, if you get one of these scary letters, Google it, you will find more information, and know that this is a very commonly employed tactic. And the final thing that he mentioned, which I thought was really interesting, is for people with disabilities. And what he mentioned is that it's very common for employers to not immediately accept the disability exists. Even if, you know, you've talked about it at work and all the other things, they'll essentially make you prove it at one of the first hearings. And again, that can be pretty demoralizing and scary if you've never had to do that before, especially, you know, you're being asked to prove your lived experience. But often, the judge said, you know, it's pretty common that once they're asked to prove it, they're able to prove it. There's not a massive high bar. The Equality Act is pretty clear about what a disability is. So again, if you're being asked to prove this, please know that this is a common tactic and just bring your evidence and do your best.